Hello and welcome to day 20 of the HubZone Small Business Virtual Summit. We have covered a lot of serious topics over the last couple weeks and nothing new here. Here today we have Joshua Duvall, a partner at Maynard Cooper Gale, to cover some key issues impacting the small business, specifically bid protests. I know a lot of you have probably been in this situation before, and you definitely want somebody on the other end that is very familiar with this process and has your guys' best interests at heart. Small businesses are constantly, fighting and grappling for contract awards. And sometimes there's a lot of nuances with that bid protest process that, we need those industry experts here. So I know you guys didn't come here to listen to me talk. So I am going to try to wrap this up and, bring the key event to the table, Mr. Duvall. So I just wanted to give a few moments because I see that there's quite a few people trickling in and I didn't want anybody to miss this great information that he has going. So I will be covering the slides for Mr. Duvall. I did forget to ask, do you prefer questions throughout the presentation or would you prefer individuals to kind of wait till the end? Like, what is your preference?
I'll work quickly to try to get through everything and then we can take questions at the end. That way they're all kind of together.
And you're really not on a time clock. I realized that we did 1 to 2, but if it's a really engaging conversation you go over, pending your schedule is available. There has been quite a few of our presenters that, once we get into that open dialogue, we just keep going. So that's perfectly fine. But I also realize that you're probably very busy. But this is going to be recorded, as you guys heard when we first started, and that will be posted in the virtual event platform under his presentation once this is completed. If you guys do have any other questions, feel free to leverage the Q&A function and or the chat box. And with that said, I'm going to go ahead and go off camera and stop talking. So Mr. Duvall.
Thank you, Michelle. And I want to thank everyone for joining us today. My name is Joshua Duvall. I'm a partner at the Washington, D.C. office of Maynard Cooper and Gale. Today, we're going to talk about Bid Protest 101, what GovCons need to know. Quickly here, if we want to go to the next slide, as I mentioned, I'm a partner in Maynard's Government Solutions Group. We have an office in D.C. as well as in Huntsville. If you want to go to the next slide, we have a couple slides here that kind of give an overview of our firm. And at the end, there's a number of slides about kind of the firm more broadly. But if we come through here, if we go to the next slide, just kind of briefly, our Government Solutions Group, we hit everything from bid protest to procurement litigation, M&A, compliance, all the things that we would sort of come to think about when you're dealing with government contractors. I've worked for government contractors, small, mid-sized government contractors prior to practicing law. I know what it's like to be in the team environment, when you win a recompete or when you lose it, your cubicle buddies and your office mates are kind of rebadging to another contractor. So it was a fun time. And so I kind of understand the government contracting industry from both having spent time working for government contractors as well as practicing law. If you go to the next slide, that's me, a more brushed up picture of myself. The one thing to note here for anyone that doesn't know me, I regularly blog about government contracts issues, and that's on govconjudicata.com. I have a LinkedIn page for that as well as a Twitter feed. And there you'll find, weekly updates. So I usually do a weekly debrief on Fridays that kind of encapsulates some of the things that are going around the horn here in the Beltway area for government contractors. And then, articles that I publish on, bid protests or, SBA regulatory updates, et cetera. So there's that. And if we go to the next slide as a sort of quick introduction, and I hope everyone bears with me. I believe these slides are going to be emailed to folks. So if you're trying to take down notes and I'm speaking at a rapid pace, don't worry, I'm going to cover everything here, but you should get a copy of it. And I'm always available if you have questions. The slide before this, just as a quick thing, I'm not here to dispense legal advice. It's sort of a generalized information session only. But if you do need a lawyer, please feel free to contact whomever you so choose. As for the syllabus, next slide, sort of when I think about protests in the government contracting space, I think it's important to talk about debriefings as well as protests, because in many instances, particularly for those who are shooting for task orders above a certain threshold, as well as procurements that are competitive under FAR Part 15, you're going to receive a debriefing if you timely request it. And there will be some impacts to protest timeliness and things that you should be aware of. And then, but if you're sort of falling outside of that, ambit of a quote debriefing, you might have a brief explanation, right? Which is a lot more, it's you may not get as much information, but colloquially, folks still tend to call those debriefings. But when I talk about debriefing, I'm really thinking of a FAR Part 15 debriefing. We'll slide from the debriefings into GAO bid protests. Instead of talking about agency level GAO and Court of Federal Claims, we'll focus mainly today's conversation on the GAO protests. The law at the Court of Federal Claims is slightly different than GAO, but it's very similar. And most folks are probably more familiar with GAO as it is an expeditious forum for bid protest resolution. We'll talk about some of the likelihood of success, what those arguments tend to look like, and then intervening. So when you've won the award and someone protests your win, as the awardee, you have the right to intervene in a protest of GAO. And so why you would want to do that, what are the things that you should be thinking about, and what do bid protest attorneys like myself think about? And finally, we'll sort of turn it over into a Q&A session. The goal here, if anyone knows how I operate in the webinar space, it's basically to try to give you a holistic overview from a lawyer speaking to folks in the government contracting space, not to really get into the nuts and bolts of the law, but so you're armed with enough facts and you have enough information floating on in your head that where you are coming up against a protest, you've got these little light bulbs that can kind of trigger that make you think of something, right? Because protests are pretty complicated. There's a lot of complex procedural issues, and then you have the complex legal issues to kind of go with it. So we're not going to obviously talk about all that today, but importantly, we're really just trying to give you some information. So when things kind of hit, you kind of have a light bulb moment to go like, oh yeah, I remember that and that webinar. And it may not even be my webinar, maybe someone else's webinar, but just something to think about. And so from that, let's sort of go to the next slide and kind of launch into debriefings. So when we think about debriefings, we think about transparency and procurement. They're not really available. I mean, you don't really see or hear of a debriefing in the commercial context. Like, hey, I lost this big RFP with XYZ Fortune 100 company, right? I want to know why you didn't select me, right? You may get that opportunity, but there's no codification of that, right? Here we have an opportunity to learn why you weren't selected for the award. If you're the awardee, you obviously have the ability to request a debriefing as well. But I'm thinking about it from the viewpoint of an unsuccessful offeror. Folks use the debriefing not only to kind of determine whether there were flaws in the evaluation process, but also to kind of get that information. I think the two watchwords I tell folks is information gathering, and relationship building, right? So we're there to build relationships with agency personnel, and those relationships can be forged, whether it's a phone call or an email. There's some things that you can do, and also to kind of get information. We're not really using the debriefing process to explain why the evaluation was incorrect or what they had missed or what they had overlooked. It's really just to extract and get as much information as you can. As I mentioned, a debriefing for the purposes of today's conversation, and when we talk about debriefings as a term of art, are those under FAR Part 15, and for task and delivery orders that exceed $6 million under FAR 16505. When we go to the debriefing, I also want for folks to think about, if we can go to the next slide. I don't know if we can hear me. There we go. I've sort of lost control of my laptop here, so I'm not sure what's going on. But so requesting a debriefing. So when we're talking about a debriefing, this is really, sorry for that. I don't know what happened with my computer. It kind of froze, so I don't have the ability to see what my upcoming slide is. But when we think about debriefings, we have the pre-award debriefing and the post-award debriefing. For pre-award, we're usually getting a notice of exclusion. We have 3 days to request it. For post-award, likewise, we have 3 days from your notice of award. When we're thinking about pre-award debriefings, one thing to note is always when you request your debriefing, first thing to remember is the timeliness, which I believe is on the next page. If we can just go to that. Agency COB under the FAR is 4:30 p.m. local time. And so when we say that you have 3 days to request the debriefing, if you request that debriefing at 5 o'clock on the third day, unless the agency's website or some other thing, thing in the solicitation, for example, indicates that the agency COB is, for example, 6 p.m., it's going to be treated as filed the next day because you filed it after 4:30 p.m. local. And that's important because to trigger the requirement that you receive a debriefing, it's got to be timely filed. So what I generally tell folks is to, make your request the day that you receive it, right? Take the first date offered. And if you're receiving a pre-award, like notice of exclusion, you're requesting a debriefing, don't delay that. The government may wish to say, hey, Josh, we appreciate you requested a debriefing. We're not going to give it to you until after the award. If the government takes that at their own initiative, then that's okay. But as a unsuccessful offer war in that instance, or one where you haven't been put into the competitive range, you do not want to delay that debriefing on your own volition. It has some impacts on GAO protests. I don't want to go down that rabbit hole, but for the sake of clarity, if you're requesting one for the pre-award, notice of exclusion, take it right then and there. Even if the government asks and they tell you that it could be different information, just take it right there because it could, like I said, could impact your protest. As I mentioned earlier, awardees and unsuccessful offerers both have this opportunity. And importantly, and which is why I kind of rope in debriefings into the conversation generally, is that they do have an impact on protest timeliness, right? And so when we're talking about GAO, they have very strict deadlines. And if you don't timely file things and if you don't meet these deadlines, GAO will not entertain the protest. So if we can go to the next slide, that's sort of a key disclaimer that I think folks need to be thinking about. And going back to this pre and post award type of debriefing, here's what you're getting under the FAR. And it's important to note the word minimum requirements. The FAR says, here's the things that at a minimum, a debriefing has got to include. A lot of agencies treat that as, unfortunately, the maximum, right? Now, there's things that the debriefing cannot include, and those are the prohibitions. But in terms of the minimum requirements for a notice of exclusion, you're going to get the agency's significant elements of your proposal, the summary of the rationale, and reasonable responses to relevant questions. That is a nebulous and vague thing that some folks don't like, because sometimes the answer you receive from the government is, we adhere to the stated evaluation criteria in Section M. The evaluation is consistent with that and therefore reasonable. If we go to the next slide, we'll see on the other hand, we have the minimum requirements, but what is not going to be included? Well, you're not going to learn how many people submitted an offer, their names. You're not going to learn anything about their proposals or the ranking. Now, these are the things that are not going to be included in a pre-award debrief. Now we can go to the next slide. So let's transition to the post-award debriefing. So if we go to post-award debriefings, this is the thing where you've received a notice of unsuccessful offer war letter, and now you're thinking, okay, I want to request a debriefing. This is under FAR Part 15. What am I going to get, right? And under the FAR, again, we have the minimum requirements. And so at a minimum, you're going to receive the government's evaluation of the significant weaknesses or deficiencies. Those are both defined terms under the FAR. The overall evaluated cost of price or ranking, if one was developed, a summary of the rationale for the award, and reasonable responses to relevant questions. So there are these minimum requirements that you're going to be receiving. On the other hand, what are you not going to get? And that's the next slide. We're not going to get a point-by-point comparison. We're not going to get trade secrets. We're not going to get privileged or confidential information, cost breakdowns, profits, and the like. I mean, this is actually very, it's good news for folks in general, because that means that your information is going to be protected, right? The government's not going to give this type of information out. But when you're the unsuccessful offeror, you're kind of like, man, I really wish we had more information, but you're not going to get it because obviously it's not permissible. But it is satisfying to know, at least from a competitive standpoint, that your information isn't going to go out there. If we can go to the next slide. Again, I don't know what's going on here. I'm having trouble. When we talk about debriefings, one thing I think to think about, in addition to just the general notion of debriefings under the FAR, is the Department of Defense, and has these enhanced debriefings, right? And under Title 10, as you can see the citation, it says that offers have an opportunity to submit within 2 business days after receiving a post-award debriefing additional questions, right? So you have this opportunity to sort of get further amplification and explanation as to why your proposal wasn't selected, or what the agency liked or didn't like about your proposal. This is also important because, as I'll get into later on, the debriefing is not considered closed until the government delivers its written response. So that's going to be key when we're thinking about protest issues down the line. The Department of Defense issued a proposed rule in May 20th, 2021, that sort of seeks to codify and put into the regulation some of the issues that were in the 2018 NDAA. So that's great. We should, I'm not sure when the final rule will be published. I didn't get that, but that's something to be thinking about. But if you're in a DoD procurement and you have the opportunity to request enhanced debriefing, I'd recommend doing it, because you have that right under the statute, and it will again delay the protest shot clock by virtue of the fact that the debriefing isn't closed until the agency delivers its written response. And so if we can go to the next slide. And so all of this sort of background information that I just provided is really to set the table for what I call like a 3-phased debriefing approach, right? So we've got this pre-debriefing, what am I going to do to prepare for the debriefing, right? Well, if you're in the business of doing work with federal contracting, you may have submitted or will be submitting several dozen proposals over a year, right? Maybe it's only 5 or 6. The time in between proposal submission and when you're learning of the award can vary depending on the agency and the procurement and what's going on. But it's not unheard of for it to take a couple months, right? So what we want to do when we've been notified, particularly that we've lost, is go back, reread our proposal, reread L&M, kind of come back to the 15505 and 506, depending on the debriefing, like figure out what was asked of you in the solicitation, how did you respond, how you were going to be evaluated, and use that information to prepare questions and send them in advance. I know a lot of folks do that, some don't, but you can. Doesn't mean they're going to respond to them all, but it's something that you can do to kind of cue the agency as to what you're kind of wanting to uncover during the debriefing. And again, it's not always specific questions targeted at I'm going to protest, but it's also an opportunity to, what didn't you like? What could we have done differently? We thought we explained ourselves. We're receiving. What were we missing here? Because at the end of the day, if you can't really improve that which you don't learn from. So if you're not learning anything through the process, your next proposal isn't taking advantage of these lessons learned. When you get to that debriefing phase, so now we're in the phase 2 of this 3-phase approach, what the agency is going to will and will not tell you, right? You've looked at the FAR. If it's on the phone, or if you have a Zoom or whatever, bring someone and have their job is basically to take notes and listen, right? We want to make sure that we're hearing what the agency is saying and understanding, the information that they're trying to convey. And again, be polite. The debriefing isn't an opportunity to explain why your proposal should have been rated higher, or why the awardee's proposal couldn't have been, awardable or whatever. That's for a separate, if you're going down that route, that's really where the protest function is. It's not really the purpose of the debriefing. And then after the briefing's over, we have like the post debriefing, right? We have your, group up your LT, your leadership team, grab the proposal writers, kind of convene and figure out, how do we improve? What are our lessons learned? Were there flaws in the procurement? Should we protest? Do we need to make a go, no go decision? As I mentioned, GAO has quick shot clocks. And so, these decisions are often made on short order with imperfect information, but with as much information as you can at the time that that the decision is being made. And so that sort of encapsulates the debriefing aspect and sort of this three-phased approach to sort of orient yourselves to thinking about, okay, I have this opportunity for a debriefing. How do I take advantage of it? Right. And so, I always mind folks to kind of keep that in the back of their mind and don't just approach a debriefing from the passenger seat or on the bench. Correct. If we can go to the next slide now.
Before you go into
Yep.
bid protest, can I ask a question real quick?
Sure.
So with debriefings, is it only applicable? So what if happens if you were awarded a contract and you have option years and they so choose not to exhaust the option years? Does the contracting officer have to give you any sort of debriefing as to why the option years were not exhausted?
So the exercise of an option year is a contract administration issue. What we're talking about in debriefings are related to contract formation, like the decision to award a contract. I suppose you could always ask for a contracting officer to give you information as to why they aren't exercising an option. But under FAR Part 15, this is when you've received a notice of an award. That's when, as an unsuccessful offeror, the shot clock starts for you to request a debriefing in order for it to be considered, quote, required. Does that make sense?
No, it does. But that's actually the question. I was trying to see if it was kind of one and the same, like if
No,
it
it's not.
correlated, and you answered the question that it doesn't. So
Yeah,
that
you can.
answers my question.
I recommend asking those questions because there's a lot of the agency is doing things that you may not be aware of, and they might say, "Hey, we're not exercising the option." It would be unfortunate if the agency didn't give you some sort of heads up and you didn't really understand that's what was coming. But at the end of the day, they're the customer, and if you have an opportunity to kind of maintain, great relations with them and show them that you're, looking out for the government's interest and trying to, be a good steward of the responsibility you have as a government contractor, that will be, probably more beneficial. But there isn't really, I wouldn't say it's a debriefing, right? It could be something else, but not a debriefing. So that being said, very good question. Thanks, Michelle. Let's turn into this bid protest. When we think about protests, we think about fairness, integrity, accountability, and transparency. How do we protect against fraud, waste, and abuse? Unfortunately, when you read enough bid protest decisions like I do, and you're involved in a number of protests, things sort of shake out, and not every procurement is flawed and not every procurement is not flawed. There's just some procurements that have issues and it's a complex world we live in with government contracting. There's a lot of, regulatory issues. There's a lot of ethics issues. There's a lot of OCI issues that sort of come up periodically. There's a lot of things that come up, and, if we wouldn't have this bid protest process, there wouldn't be a way of really uncovering it. And that is sort of the purpose of this very old 1970s DC Circuit Court quote about the public interest in preventing the granting of contracts through arbitrary and capricious action could be properly vindicated through those who are basically the protesters, right? The key aspect here is this, it's brought to the public interest, through these private attorneys general. Now, this case was, at a time when district courts were hearing protests. The Administrative Dispute Resolution Act of 1996 sort of sunsetted that, and then starting in January of 2001, the federal court for protests is the Court of Federal Claims, right? So prior to that, you had these decisions throughout these other district courts throughout the country. Now you've got Court of Federal Claims, right? And so, but this quote is actually kind of interesting, particularly in light of the fact that you have these OTA issues that are coming up, and folks are trying to think of how you can protest an OTA. It's not a procurement, so it's not subject to the Tucker Act. We can't go to court. The federal claims, maybe we can go to some other jurisdiction. So, but that's sort of the broad theme here is I'm a disappointed bidder. How do I seek remedy if I think there was a flaw, right? Whether there's pricing issues or evaluation issues, or like a former government employee, goes to another, company, there's things that come up. This is where this protest mechanism sort of fits in. If we go to the next slide, We talk about the fora, right? So where can I go if I have an issue that I want to challenge? Well, you have the procuring agency, right? The agency has their best efforts to resolve these within 35 days. There's no statistics. You don't have like a report that GAO submits to Congress on an annual basis. And there's no universal filing system for agency protests where you can kind of see what's been filed and who made the filing and what arguments they made. They're just not there. And one other sort of side note here is the FAA has the Office of Dispute Resolution for Acquisition. They don't follow the FAR. They have the Acquisition Management System. That's sort of a separate thing. The next, I'm saving GAO for last here, but we have the Court of Federal Claims on the previous slide. It's a federal court. It's an Article 1 court. The judges are not what we would hear as an Article 3 judge. They have a 15-year tenure, and some of them will take senior status. The Department of Justice are the attorneys that will defend the United States. So unlike the Government Accountability Office, where you have agency attorneys involved, when you go to the Court of Federal Claims, those agency attorneys are still involved, but the first chair litigators are the Department of Justice. And there's some procedural differences because now you're in a court, you have motions practice and briefing and things of that nature. And finally, in sort of the overarching purpose here today is the next slide, are GAO protests. The GAO is a legislative entity, so they only make recommendations to federal agencies. We're talking about separation of powers, right? The legislative branch can't tell the executive what to do, but in this case, GAO is just making a recommendation. They handle 2,000 or more than 2,000 protests on a yearly basis, and we see those statistics in their bid protest annual report to Congress, which is filed usually in the fall, sometimes as late as December. But after the fiscal year's up, they prepare it and send it to Congress, and it's published on GAO's website. It's set up to avoid unnecessary delays in the procurement cost and to keep these protest costs down. I mean, the Government Accountability Office has a statutory deadline of 100 days to issue a decision, so they go pretty quickly. They're filed electronically. For years, they were just, you send an email, and now we have an electronic database that you use to file these protests. And one thing that you don't have at the court, but you do have it at GAO, we have is the seek a stay when you timely file a protest. So if we can go to the next slide, just generally, this is kind of what this is from GAO's website, sort of gives you an idea of what happens when you file your protest. There's a lot of things that start to take place. An intervener may enter an appearance. The Department of Justice, the agency attorneys may file requests for dismissal if you're untimely or if you're not an interested party. But all that is leading up to the fact that they've got to produce this agency report on the 30th day. And accompanying that is a memorandum of law explaining the agency's position, right? And then when that happens, you have your 10-day window to kind of file your comments on that and also supplement your protest with any new information that you uncover during your review of the record. And then the agency has to, or the GAO has until the 100th day to issue a decision. There's a significant number of protests that are resolved through voluntarily withdrawals where the agency decides to take corrective action and the protest is dismissed. Some protesters will file a protest and they withdraw when the record doesn't sort of unfold in the manner in which they would prefer. This sort of just kind of gives you an idea of just kind of what to expect. Again, this is from GAO's website. If we go to the next slide, when we think about protests, I think about two main buckets, really. We have the pre-award bucket on the one hand and the post-award bucket on the other hand. So when we think about pre-award issues, we're thinking about, are there ambiguous or conflicting terms in the solicitation? Is there language that unduly restricts competition? Is the evaluation method unreasonable? Or there are provisions that violate law or regulation, like if there's something that violates SBA's regulations in terms of how they're going to evaluate a joint venture, for example. These are all things that you would bring up pre-award, which is generally you're filing these prior to the proposal deadline. When we think about post-award protests, generally we're thinking about evaluation errors, right? Sometimes we'll learn of an OCI, but we're really looking at the technical evaluation was flawed, past performance was flawed. There's an error in the price evaluation or combination of these, and which all leads to an infected trade-off decision, right? And so that's sort of what we're thinking about, in both the pre-award and the post-award context. One other thing to remember on the next slide here is task orders. A lot of the way that the kind of government is moving nowadays, we have a lot of best-in-class vehicles and these IDIQs and GWACs where task orders are issued against a master contract. Sorry. I think I skipped a slide, but I'll go back to that. So when we think about protesting first, who can protest? It's an interested party, right? If you're an actual or prospective bidder, you can, whose direct economic interest would be affected, you have the ability to file your protest. If you're too late in the line of the ranking, you may have a challenge at the post-award stage of trying to establish that you were prejudiced by the errors. So that's something to think about. Which these two concepts kind of you could spend an entire webinar on, but we'll leave that sort of how it is. And then, as I mentioned earlier, if you're an intervener and you're the awardee, you have the ability to intervene. If we go to the next slide, so then task orders, which is one more slide, task orders here. So what are we talking about with task orders? GAO has jurisdiction to hear a protest of task orders. So that means if the value of the task order for civilian procurement is greater than 10 million, or DoD, NASA, and Coast Guard greater than 25 million, the GAO, the Government Accountability Office, has that jurisdiction. They also have jurisdiction if it increases the scope, ordering period, or maximum value of the underlying contract. That's what we hear when a protest attorney read an article that talks about task order jurisdiction. That means like you can't go to the Court of Federal Claims absent increasing the scope or ordering period or maximum value, right? And so that's the FASA bar, which is the subject of some protests that sort of come up at the court. And so if you have a task order the value of which is underneath this threshold, GAO doesn't have the ability to hear it, right? And so that's something to think about when when you've received a notice of unsuccessful, for example. These are the things that you're thinking about. Like, can I even challenge this thing? In terms of jurisdiction, OTAs is a separate thing, but I'm not going to get in there and sort of the nitty gritty with that. Timeliness, as I mentioned on the next slide, GAO has very, strict filing deadlines. You've got to have this thing electronically filed by 5:30 p.m. Eastern on the date that the protest is due. Essentially, you've got to pay your filing fee by that deadline for it to be considered filed. If you miss that deadline, and how does that happen? So that, briefly, there have been cases where we have these GAO 10 days known or should have known rule, right? And we're not talking about the SICA stay, just 10 days known or should have known. There have been a couple protests where the agency informed the unsuccessful offerer of the basis of protest during the phone call. And that was subsequently, memorialized in an email a day later, right? And in a couple protests, GAO held that the basis of the protest was the phone call, not the email memorialization of what actually was said. And so that's something to be aware of when we talk about 10 days. They really are not going to budge on that. As I mentioned earlier, if we go to the next slide, for solicitation defects, again, ambiguous terms, restrictive competition, unreasonable evaluation methodology. GAO's regulation provides that, these improprieties have to be filed prior to the time receipt for initial proposals, right? So, when you're thinking about what happened over the summer, a lot of these CIO SP4 protests, they were all getting filed prior to the deadline for proposal submission because they wanted to get it in. And the reason you do that is because you cannot let a patent ambiguity through, sort of roll the dice, be evaluated in a manner that was inconsistent with how you thought the solicitation was being to be read, and then try to challenge the solicitation as being ambiguous after the fact. They're just not going to allow that. And for protests that are other than solicitation defects, which is the slide that we're on now, we're talking about protesting evaluations, award decisions, exclusions from competitive range. We have this 10 days known or should have known rule. As I mentioned, you can, been instances where this information has been learned during a phone call. But there is as an exception here, right? We have this 10-day known or should have known thing. Like, how do you know? Well, what happens when you, as I'm going back to what we talked about at the beginning, what if I've requested a debriefing, right? Well, that's where this comes in. We have an exception to this 10-day, and it also is sort of, GAO won't allow you to file your protest before that. So you still have this 10-day rule, but you also have this other thing called the seek a stay, which is 10, and we can go to the next slide, which is within 10 days of award or within 5 days after a required debriefing. So most often your debriefing will come a little bit later than, when you've learned the notice of award. Sometimes you get it quickly. But, if you've timely requested your debriefing, and the debriefing ends, you have 5 days to file that. So you're going to get 10 days, but if the debriefing happens on the 8th day, right? Well, you don't have to, to file your protest at GAO, you've got, you're not allowed to file it prior to the debriefing. And then you learn the information for your protest at that debriefing. You have that window. But really what we're thinking about as protest attorneys is triggering the seek a stay, which is even a much shorter window than this 10 days known or should have known rule, which is this 5-day rule, right? And as I mentioned, there are DoD enhanced debriefings. If we go to the next slide, and that's where, as I mentioned briefly earlier, we have an opportunity to submit these written questions within 2 business days after receiving the debrief. And then importantly, under the regulation, it says, which is the last sentence, basically in the middle bullet, the agency is not allowed to consider the debriefing closed until they deliver their response to you. So you always want to ask these questions. Now, there was a case where the protester didn't ask the questions, and the Federal Circuit essentially said, the opportunity to ask the questions does not extend the deadline. You got to ask the questions in order to trigger the change in deadlines under these often confusing timeliness rules that folks need to be thinking about. But so I guess if I were to distill all of this into kind of one theme is, we've got to pay attention to dates, right? We've got GAO's 10-day known or should have known rule. If you requested a debriefing and it's required, you got to wait till you have the debrief. But if you want to trigger this stay of performance, which is statutory, which means that the agency cannot, commence performance with the awardee during the pendency of the protest, you got to file your protest within the SECA mandated deadline, right? Because that's what you want. You want to halt what's going on if you think that the protest or the procurement was flawed or the evaluation was flawed. And so that's critical. As I mentioned, the Court of Federal Claims doesn't have a seek a stay, right? You have to basically get either the court to grant you a stay, or you have to agree. Usually the agencies and the government attorneys will do that, which is they'll agree to sort of a stay pending the outcome of the protest. But it's not a statutory right that you have when you're filing at GAO and pursuant to SECA. Now, if we go to the next slide here, just some quick notes. GAO is not going to consider a contract administration issue, SBA size protests. Those are different. Untimely protests, as I mentioned, they're not going to entertain those. If you don't meet the threshold of a detailed statement of the legal and factual grounds, you can have your protest dismissed. If your subcontractor tries to file a protest, they aren't the offeror, the prime contractor is, so GAO will dismiss that. When we talk about success rate, so we've sort of covered a lot of these procedural hiccups and like what does it really mean to succeed at GAO? There's a lot of, I think, varying definitions. But if we go to the next slide, we have a chart from, as I mentioned earlier, GAO's annual report to Congress, and they, as I mentioned, are required to file a report every year. And basically indicating the circumstances under the area, the agencies that decide to, I'm not going to listen to the agency's decision or recommendation from GAO. I'm going to do my own thing, right? GAO's got to let the Congress know when an agency doesn't take GAO's recommendation. They most often are, but here, and I'm hoping that the slides are big enough for y'all to see. What GAO also does, in addition to including their most prevalent grounds for sustaining protests, is they actually give you some nifty statistics. In 2020, there were 2,137 cases closed, and they sustained 545 protests, right? or merit decisions. They sustained 84 of those. So there's 545 decisions actually went to a decision, 84 were sustained. So you have this sustain rate, 15%, right? So what does that mean? Well, if you're sustained 15% of the time, that seems kind of a low number. But the thing that it doesn't really account for, and this next statistic does, is the effectiveness rate, which is the number directly below it, which is 51%. The effectiveness rate at GAO takes into consideration, not only the protests that were sustained, but also the instances in which the agency decides to take voluntary corrective action. So if you have uncovered procurement errors on the basis of the debriefing, and the agency realizes that there may be an error in the procurement, or they didn't exactly conduct the evaluation in accordance with Section M, which sets forth the evaluation factors, the agency might decide we're going to take voluntary corrective action. When they take corrective action, the GAO will dismiss the protest as academic, because they're not going to listen to a protest that when the agency's decided on its own volition to do something different, right? And that's usually in the form of a reevaluation of some sort. Well, GAO's statistics say that 51% of protests are effective, right? They're either sustained, or the agency pulls back and reevaluates or makes changes to how they evaluated. So that's great news for folks, because I think it shows that the protest process works. I think we would love to have more details in these. Obviously, we don't know how many protests were filed that were untimely. We don't know how many protests were filed, that were dismissed for other reasons, right? But so this sort of takes into every type of protester's argument and lumps it in, right? So, I mean, if they discounted untimely protests, would the statistics change and look more favorable? I don't know. But what we do know is that for the purposes of GAO, the 51% are effective. Now, what does it mean to be effective and have a sustain, right? What's going to lead to that outcome? Which I think what folks want to know. And that's sort of the success rate. The next slide, the successful protest grounds. As I mentioned in this annual report, which I didn't copy and paste anything else from it, GAO will list the instances that are what they determine the most prevalent grounds for sustaining protests. It's usually 4, sometimes 5 protest grounds, and it's usually unreasonable technical evaluation, unreasonable cost or price evaluation, flawed trade-off, failure to document the record. We're not looking for, as a protester, as protesters counsel, we're not looking for the subjective arguments, right? Sometimes the protester's argument sounds subjective because that's how they're able to articulate it. But when I'm thinking of a protest argument, I'm thinking of how is this procedurally flawed, right? How is this objective? Because GAO can latch on to something that's objective, because it's no longer, I disagree with the agency. It's, I disagree with this procedural error, which is the reason why I'm disappointed with the agency, right? And that procedural error could be, hey, you said you're going to evaluate us on A, B, and C in Section M. I'm getting a lot of, in this summary of the rationale for the award decision you provided me, it doesn't say that. It says that I was rejected for D, E, and F, right? Well, as a government contractor and a bidder, you're thinking, well, had I known that that's how I was going to be evaluated, I would have written about D, E, and F in my proposal. So that's an objective type of flaw where you can say this is not what they said they would do in the solicitation, right? That's traveling outside the stated evaluation criteria. So that's objectionable. Maybe there's a price or a cost argument, right? If there's a price realism analysis requirement in the solicitation for a fixed price contract, and the agency is required to do it, and the awardee's price is really low, you may have some ground there. Now, it's not always required in fixed price contracts, but that's something to be on the lookout for. Or unequal treatment, right? When you get into the record, well, they were given strengths for this, and we basically wrote the same thing. To the extent that we can, put those on a level playing field, that might amount to unequal treatment, right? So there's a lot of things you can do, but at the end of the day, when we're thinking about successful protest arguments, we're thinking about these arguments that are objective and procedurally based, right? And again, when the protest process is very much a process, and there's a lot of nuance to filing a GAO. There's record differences between GAO and the court, and that may play into the go, no go calculus, right? Should we go to GAO? Should we go to the court? And there's timeliness issues that come into play. And there's, issues when you're challenging a FAR Part 15 versus, when you get a brief explanation for some other type of procurement where you don't have as much information with which to work. Maybe it changes how you approach and where you want to go. So that sort of gives an overview, I think, of, well, I'm a disappointed bidder. I've lost. Where can I go? How can I fight it? Right. I'm not one to say that folks should be protesting everything. I think there's a time and place for protesting, and it really is rooted in these procedural errors. Now, what happens on the other hand if you're the awardee, right? Well, if we go to the next slide, as I mentioned in the beginning, you've got an opportunity to intervene, right? You're the awardee. You've just won a contract. Maybe it's a strategic contract. Maybe it's a high dollar contract that's also strategic. Maybe it's your first big win, or maybe it's setting you up, maybe it's, a key win that you need in order to be able to bid on something is coming out a couple of years later, because you're going to lean on that past performance, right? Well, say someone's protesting your win. Now, what do you want to do? Well, you have an opportunity to protect that by intervening, right? And there's a couple of reasons I think that folks want to intervene. A, you're the awardee, you have the right. If we can go to the next slide. But what do you do with that, right? How do you approach it? Well, there's a couple things to think about, right? First, I think a lot of the agencies, particularly DoD and procurements that are of high dollar value, they kind of anticipate that the awardee may intervene. So you're not in the shoes of a protester challenging. You're on the other side. You're saying, I want to help the government protect the award. With that being said, the government has different obligations, because they've got to treat everyone even-handedly, right? So even though they want to protect their award decision, right, they aren't necessarily perfectly in parallel with your objective, right? But also another reason for intervening is like you understand your proposal, what your strengths, you understand your solution, and so to the extent that you can leverage that to help the government and in participating in the protest defense, you can do that. I think there's like really two kind of flavors, I think, for intervening. You have this active, you're really very much defending, the win, right? Whether it's requests for dismissal, being a resource to the agency. Sometimes the agencies are just dealing with a lot of work, not enough time, not enough people, and to be a resource, to lend a hand. Hey, if you need us for extra research or anything like that, let us know. Or you can be sort of on the monitoring side, right? You've intervened, you've entered in the case, you're in the protest, you're seeing what's happening. You may or may not need to write a brief. That may be because the protest is untimely, right? Or you may write a short brief explaining why it is untimely, but you're not really getting in the full weight of the argument as you would at the protester, where you've got to explain the protest. Now, if you're actively intervening and it's a lot of back and forth technical issues, cost issues, you get a lot of, maybe there's, multiple interveners because it's a multiple, you're getting multiple protests from different angles. It takes a lot of work sometimes. So there's different tacks depending on the size, nature, complexity, and scope of the procurement. And also, as I mentioned, there's some procedural differences here at the GAO. You've got a relevant record, right? If I'm making my protest argument, the agency's got to furnish records that are relevant to the protest that I've made. At GAO, it's the full record. I mean, at the court, it's basically the full record. So you'll get every now and then you'll see a Court of Federal Claims decision where there's a footnote, sometimes in the text of the decision, but usually I've seen them in footnotes where they say, hey, look, the protester notes that the record they received here is slightly different. There were materials missing, and that's why we shouldn't even think about why the GAO dismissed the protest, because they didn't really have all the information in front of it. So to the extent that you can, as an intervener, limit the record production, that's something in your favor, obviously. We go to the next slide. And, GAO will usually issue a protective order. So you file a protest as protesters counsel or request that a protective order be issued. When you come in as an intervener, your outside counsel is able to see the unredacted protest, unredacted, you know, source selection, right? And that's critical because if you don't have that information, if you're not under the protective order, and they're not going to give it to folks usually that are not represented. There's too much confidential information that are and proprietary information. And I think this sort of goes back to what I was talking about with the briefings. You don't want your information out there, right? You want there to be, you want to know that your information is safe from the eyes of your competitors, and with the understanding that their outside counsel will see it, but they're not allowed to share that information, right? So that's something that the folks should, I think, think about as a positive aspect of the protective order, which is it's preventing your information from going into your competitors' hands. Again, the interveners may not necessarily align perfectly with the agency's objectives because they've got overarching procurement objectives, notwithstanding, protest specific objectives that they want to have, right? And so you can also use the intervening opportunity to kind of shape the scope of corrective action. We've seen that in a number of protests. And again, as I mentioned earlier, you're supporting the agency, whether you're urging GAO to deny the protest or to dismiss the protest for whatever reason, filing requests for dismissal. I mean, all these, you don't have that opportunity if you're not participating as an intervener in the protest, right? So, again, when we're thinking about protests, first I like to set the stage. Am I in the territory of where I am eligible to receive a debriefing from the government? Is it that type of procurement that's covered under the reg? And if so, can I request it and make sure it's requested timely in order to trigger the requirement? Because as I mentioned, if you miss the deadline, the agency may very well give you a debriefing, but it won't be, quote, required, which plays into a lot of GAO's timeliness rules, right? Once you have that information, how can we improve? What can we do to improve our proposal? How can we write a better, narrative, whether it's executive summary, technical, utilization of charts and graphs, anything that you can use and information you can extract from the agency to kind of better yourself for the next go around, but also to use that opportunity to kind of figure out what happened. Some folks make the decision early on. This is a very important procurement. We've dotted our I's, crossed our T's. We've got to have this victory. Our P win is at a certain threshold. We feel confident in what we're doing. We know the customer. If we lose, we're willing to protest. I mean, and sometimes that's the case because, you just know going in. Sometimes it's, unfortunate, but, the dollars and cents sometimes make the business decision, a driving factor. Like it's too big of a procurement to not challenge. So then you're into the throes of the protest. As I mentioned, there's a lot of procedural hiccups and things to think about. But most importantly, when we're thinking about protesting, we're thinking about what are the procedural errors that occurred. And then obviously here in closing, if you're the intervener, take that opportunity to intervene. You can be really thorough and really vigorously in defending it. And if the protest was untimely, you may realize right off the bat, they didn't file the time to protest, or they're trying to protest something that GAO doesn't have jurisdiction over. At least your outside counsel has an opportunity to see that, right? But if you don't have the opportunity to sort of make those arguments and make those cases or help support the agency in defending, because they may decide to take corrective action, which is the awardee you wouldn't want, or at least most do not. So if we go to the next slide, I think that sort of wraps us up. I know I covered a lot. I try to give at least 10 minutes for Q&As. I'm happy to obviously stay on for as long as folks want to ask questions. Really appreciate everyone's attentiveness. As I mentioned, I think Michelle may very well email some slides to folks that attended today. I'm not quite sure, but if you do have questions, by all means, feel free to reach out to me. My contact information was in one of the beginning slides. And so with that, we'll turn it over to Michelle and see if any folks have had any questions that I can do.
Hey, so I don't believe anybody has posted any questions yet, but the slides are posted in the system.
Okay,
so
perfect.
They can find them in Jujama. But while I have you, and I apologize for any background noise, as I mentioned, like I was having to work from home, and I apologize for the technical glitches. There was a few times where you froze a little bit, but it was very clear what you were saying because it was on the slide. So it wasn't like problematic. I could obviously follow it, so I'm sure that they could as well.
Perfect.
While we have them here, I do know that we still have a few individuals here with us. Did you guys have any questions? Rob, Ellery, anybody else have any questions for him? If not, I'm gonna probably ask a question here. So with protests, I know that there's been some changes with HubZone, which, kind of reduced them, but in your experience, do you feel like there's been fallouts? Like, so say somebody submits a protest and it's determined that it's not valid, like kind of the boy who cried wolf, does that come back negatively, or is there any sort of financial burden that comes on if somebody files a protest and then it's found to not be warranted? Does that question make sense? I'm not sure if I worded it right.
Yeah, I'm not aware of, I mean, there has been a couple years ago, there was a protester that would protest a lot. And I think JO took the position that, hey, look, you're going overboard. You're not really making protests, right? We're going to push the pause button here. And I think they basically said, you can't file a protest on a procurement for a certain period of time, but that's because they were challenging everything. My experience is that, if you're making an honest challenge, I mean, this is the whole purpose of the bid protest system. Now, is it possible that agency officials don't like that they have to deal with a protest? Maybe they're new and they don't realize that this is part of the process, or they don't like the fact that someone's challenging their determination. But casting aside those sort of subjective, thoughts, I mean, it is part of the process. I mean, there's usually language in a solicitation that says, here, direct your protests here, right? Here's the name of the contracting officer, right? I mean, it's a known thing. Now, I suppose that there may be business decisions based on knowledge of the customer and knowing whether or not the customer, how they view protests, sort of based on their experience with a particular agency or just, division within an agency, for example. And they may say, no, they don't like protests, so we don't want to do it, even though we want to. But by and large, it's not really something that I've seen where you get really a negative look on it. If you're that person or the company that's just constantly protesting without really a valid basis, I suppose you may get a decision like what GAO did a couple of years back. But if you're staying within the realm of a procedural flaw, something that was objectively wrong, then you're probably, you're making a good faith challenge to something that you think. Now, if all you have is, I don't like what the agency did, that doesn't mean that you can't make the argument, because maybe I don't like what the agency did does fall within an objective type of protest, and you just may not know how to articulate it, especially if you're filing just without counsel. But usually, like I mentioned, especially if they're a DoD agent, I mean, they deal with these a lot. I think there's some agencies that just don't see a lot of protests, and maybe you might have a different view on that. But I don't think it necessarily harms, unless you have some, unless you're a contractor, you just happen to know the shop that you're dealing with, and you know that it's not gonna, you don't want to do anything that that your customer isn't gonna like. But as a general proposition, it's part of the process, right? I mean, we have to be mindful of what we're doing, because we're impacting a procurement. But if there are flaws that give rise to these protest issues, then you've got to make the challenge. Because as I mentioned in the beginning, no one else is there to really make that challenge, right? I mean, you either protest it or you let it go, right? Some folks I know let it go until they get to a point where, like, I'm tired of letting it go. Like, I'm losing all this, I'm spending all this time, money, and energy. And I think the contracting shop keeps doing something that I don't like, and I'm going to protest to take a stand on it, to let them know that I'm paying attention, right? So there's various business judgments and business reasons for protesting. I won't get into all of them, but by and large,
well, we do have another question. Rob said you touched on this. I was surprised that we have so little time to protest. Sometimes not enough time to give it adequate thought, and there is also emotional behind receiving the decision as well. I'm concerned that a good faith challenge could label us negatively. Is that a valid concern?
I don't think well, you're right. It is a quick a quick shot clock. And that's why I think, first of all, especially if you're dealing with FAR Part 15, really getting back and, because when you've submitted a proposal in January and the award is in September, right? Like, your team has improved, presumably in writing, and maybe you have newer capabilities and you're writing better proposals, or you hired a new proposal writer, or you're just thinking about government contracting differently, right? We have, if we're learning over time, when we're coming back with fresh eyes, we can really see like, okay, what did it say in the solicitation? We're using this not only to kind of refresh our memory, but also to kind of have an objective sense going into the debriefing, like where do we really stand, right? And then utilizing that information to say, hey, wait a second, we really think this is, askew. Now, I believe, and I think, you go to like the PTAX and the scores are out there. They talk about, lining up your accountants and your bankers and all these folks, insurance companies. Like, I'm a big fan of building relationships, and I think folks should kind of invest in that time so that when something like this does come up, you're not really rushing to kind of figure out. And it's particularly true if it's a very strategic procurement for your company, or whether that's small dollar new customer or high dollar new customer or high dollar existing customer. I mean, there's a lot of wiggle room for what is a strategic procurement for a company. It could be your first win. We don't know, right? But having all of that information, then you can kind of say, all right, where are we really at? Like, okay, this, I had a protest that was at the FAA a couple of years ago, and the client was, the main issue was cost. They just didn't like how low the awardee's price was. I mean, it just boiled down to that and some other things. And when we looked at it, what the client was telling me made sense because we looked at a spreadsheet together, right? And I was like, okay, that makes sense. But by the time we got the record, it was like one of those things where like you tell the client, like, this is not, we're not going to get over the hump here, because what we originally thought is not exactly what happened. And the client at that point was like, okay, if that didn't happen, I'm okay. And they withdrew the protest, right? Which is you're allowed to do. But up until that point, he was thoroughly convinced that based on his analysis and the Excel spreadsheet that he built up, there's no way they could do it at that price. But when, now you can't really share the details of the information with the client because of protective orders, but you can, say, look, the record's not going to be fruitful here. You may want to consider backing out, and that was sort of a thing where you did. An agency, they appreciate when that happens. That doesn't mean you want to do it or you like doing it, but you don't want to waste the government's time if you're really not going to achieve an outcome, if that makes sense. So I hope that answers your question. I was sort of long-winded, but
yes, and I think it answered his question, but I also made another comment that, he made the comment of your emotions could play a role in it. If you've just worked months or spent an inordinate amount of time, money, and energy on a proposal, and then you get a response back, and then you're just like, are you kidding me? Sometimes you say things you don't actually mean. I know I've done that numerous times where the aggression comes through the way you're writing. And I think that's why attorneys are used so much in protests and with that quick turnaround, is because they do not have that emotional involvement, and it's strictly the facts. And when you're coming with a protest, that's what you have to have, because I do believe that you could negatively impact your view with that agency if you allow your emotions to come through in your record.
Yes, if it's during the debriefing, I think that that's a possibility. That's sort of why I think, at least for some other folks may have a different view, but part of the reason why I tell folks to like break down the debriefing into 3 phases and to think about it as a process is because you're not writing an email asking for a debriefing and then doing nothing and then waiting for the debriefing to happen to finally learn what's going on, right? I mean, you're obviously getting information for the first time, but at that point, it's in some instances already too late because you haven't framed your mind, right? Like by going back and reviewing, familiarizing yourself with the FAR, what are they required to give us, as a minimum requirement? What are they not going to give us? What did the RFP ask for? How do we, respond? Do we answer the mail? when you're heading into the debriefing, now you've got it's not like a reflexive debriefing. You've got time to think about from a strategic standpoint, and also time to remind yourself the debriefing isn't the opportunity to make my challenge, right? And if you have that cordial and back and forth with the agency, that doesn't mean you're not upset, but your mission at that point is just extracting information and building relationships, right? And when you're thinking about that, you're hopefully that will be the predominant theme, and you're not likely or less likely potentially to try to go down the rabbit hole of, well, why did we do that? I thought we did, because you've prepared yourself ahead of time. Now, when you come back, that's where that post debriefing, lessons learned, session happens, where you start thinking, all right, like, is there an objective basis here? Like, where are we at? Right. And sometimes it's just the sheer volume. Like if you've gotten, you can't always base it on the number of weaknesses, but if you have a lot of significant weaknesses, I mean, there's a reason why they didn't select you. Now, that doesn't mean maybe those significant weaknesses were all a byproduct of traveling outside of the solicitations evaluation criteria, which I've seen. But you may be thinking, all right, well, we probably don't have it'll be challenging to win a protest when we're this far down the line, right? And so then you really want to make sure that, okay, well, I know I'm not going to protest, so how do I get as much out of this? And it may be, hey, what's coming down the pike? Are there any other opportunities that you might be aware of that we can help prepare for? I mean, they don't, some are more guarded than others in terms of contracting officers and folks who are participating in the debriefing. If they think you're getting ready to protest, they may, put up the wall and not want to really respond. Some folks have had success just kind of letting them know we're not going to protest. We just want to know how to move forward and what we can do to better ourselves. And, maybe there's an opportunity that they weren't aware of that the agency is willing to tell them. So there's just different things that kind of happen. And there's a lot of other resources beyond me on the internet and in the government contracting community for how to approach a debriefing, what you should be thinking about during the debriefing and all this other stuff, so that when you do have the opportunity, you're getting the most out of it. And like I said, if you're approaching it level-headed and thinking about procedural issues, you're not really going into the territory of simply being disappointed with losing. You're disappointed with how the evaluation unfolded, and that's the result of that flawed evaluation, was that you lost. Now, unfortunately, sometimes you learn more of the information in the protest, which is what kind of makes it tricky, I think, sometimes, because sometimes the agency will only stick to those minimum things under FAR 15506, right? The minimum requirements for a post-award debriefing, and you get nothing more, right? You ask the questions, and the responses are, the agency adhered to the stated evaluation criteria, and it made its evaluation, in accordance with that and other applicable law. And I mean, that's not the answer you want, but that's the answer they've given you, right? Which can, sometimes be frustrating, I think, which is why I think the DoD enhanced debriefings are seeing a lot of favorable results, because the contractor is getting the information that they just wanted to know, right? Why did we lose? And I think most folks that I've spoken with, even if they put a lot of time and energy into a procurement, if they lose fair and square, it's one thing, right? But if they lose and they think that there was an issue, most folks I've talked with, that's the thing that is unsettling, because you just want to know why, right? And so, again, long-winded answer, but hopefully that sort of clarifies the air here with respect to, protesting versus not protesting, how to properly frame it, think about it, and approach it so that you really can get the most out of it, right? And it doesn't necessarily mean that you're going to protest. It's really about that information gathering, and the information you gather might mean don't protest. You might already know that you're not going to, because you know your customer, right? But you want to make sure you learn enough information to approve on your next proposal.
And just ask the question. I've had people call me to ask if they should protest things, and they have a valid justification, and they, what they've collected, it indicated that, yeah, I believe they're going to have a valid case. But then I've also had some people, and I'm like, that's probably not going to go well. It's not going to do what you think it's going to do. But I do definitely think that you answered the question. And while I was flipping through your slides, because you have a lot of great slides that really talk about the new law firm, because Josh is actually new to Maynard Cooper Gale, and I believe that you're spearheading a big part of their government contracting division. I saw on the slide that you guys have a lot of really big commercial clients. I mean, USAA and Cigna. I mean, those are some pretty big players. So I feel like you're gonna have some pretty good backing there. And hopefully, if any of you guys are interested and you are in a situation where you're looking for an attorney, Josh, obviously, as you can tell from this conversation, knows his stuff. He like throws out that FAR regs like it was, reading the back of a cereal box. I mean, like, just, a little top of his head. So, I mean, that was quite impressive.
I
And,
appreciate
I
that.
really appreciate that. I apologize. I realized I wasn't on
No,
camera,
I
but,
appreciate
that was great. And yeah,
we're fortunate.
it's definitely, you can tell even from the conversation, it's difficult. It's a lot to comprehend.
It is. And, government
So-
contracting is kind of a team sport. I think you need a team of folks at your company. And, on the legal side, it helps to have a team. And I have a lot of great team members and my partners and associates and other folks at the firm that have deep experience in government contracts. As I mentioned, I'm in DC and I have another host of folks down in Huntsville. So we're able to kind of utilize that, collaborative approach to the benefit of our clients. And it's, it's really, I love being a government contracts attorney. Anyone that asks me knows that I thoroughly enjoy what I do. I like the subject matter. I like helping people. And so it's really a phenomenal opportunity to give back here and participate for the Hub Zone Small Business Virtual Summit, as well as the in-person summit we had a couple weeks ago. I thank Michelle for your hard work and dedication to the cause and for organizing the event. And I think that's it for me.
Yeah, and I just put up on the screen to show you all the different locations in which Maynard Cooper actually has presence. So they have a pretty strong national presence and, a large client base. So if anybody guys have any questions and again, Josh, thank you so much for coming out for the strategic summit. If you guys haven't noticed, very particular about my speakers. I like to make sure I thoroughly vet each of the individuals that I have speak because I want to make sure that if I'm recommending somebody to, utilize a service that I feel comfortable and confident. And again, he wouldn't be speaking here today if he wasn't getting my personal endorsement as well.
Thank you.
He's been amazing. He's proven time and time again how knowledgeable and dedicated he is to the cause. He literally is a person that wants to go and help write like legislation and briefings and reads it. And he's like, no, but it's fun. And I'm like, we have a very different definition of fun. So, I mean, I really appreciate him. And there's multiple other attorneys within our network that are all wonderful, but they go above and beyond to really support the small business community because it's not just about, the bottom line to them. They genuinely care. And so that's what really resonates with me and with Josh is because I can tell that he cares and he has the best interest of the small businesses that he supports at heart. So that's my little disclaimer because I like to make sure I support all of my peeps that, come out and, take the time and energy in order to do this. And we are so appreciative of you.
Thank you.
And, good luck at your new position with Maynard Cooper. I hope that they realize how awesome you are. I can clip this and send it to them if they're not sure. Okay. But with that, wait, let's see here. Do we have another question here? Oh, and Rob said I'm the best. Oh, I'm okay. I'm good with that.
Thank you for everyone that attended. And thanks for everyone that.
I really appreciate it.
Thank you, Michelle.
With that,
thanks,
I'm going to
everyone.
go ahead and let Josh.
Thanks, everyone.
All right. Bye, everybody. Have a good day.